Good morning, everyone. Sorry, we don't have a microphone in this room. My name is Katrin Riley. I am a senior research fellow here at the Tulane Institute on Water Resources, Law, and Policy, and I am your moderator for today. And it is my pleasure to welcome Ryan Stoa and David Takacs. I'm sorry if I'm butchering that. And they are going to speak to you a bit about international water rights. Specifically, they're going to offer insights on recent developments in the field of international water law, including water regulation, policies, and rights. Often these systems are tested when the nation is exposed to disaster and or political strife. Ryan Stoa will address the complex and overlapping water regulations in Haiti. And David Takacs is going to analyze South Africa's post-apartheid revolutionary legal vision for marrying social equity to ecology and fulfilling the right to water. As water resources in the United States are increasingly threatened, including here in Louisiana, these examples provide lessons and guidance on using law to ensure a right to water. So I would first. Oh, and if anybody here needs to get their CLE credits, please remember to sign in on the blue sheets back there so we can get you down for those. And I'd like to hand it over to David.
Thanks. Before I start, I will say any of you who are students here who have helped organize this is the best organized conference leading up to this that I've ever been to, so thanks for all of your hard work. So in 2010, the UN General Assembly, nations of the UN General Assembly voted 122 to nothing with 41 abstentions, including the United States, that the right to safe and clean drinking water and sanitation is a human right that's essential for full enjoyment of life and all human rights. South Africa, however, beat the UN by about 14 years. After the end of apartheid in 1994, the 1996 Constitution of South Africa declared, among other rights, that everyone has the right to have access to sufficient food and water. And importantly, the state must take reasonable legislative and other measures within its available resources to achieve the progressive realization of these rights. Now, it's all very nice to have words on the paper that talk about the human right to water, but it's much more difficult to figure out how to actually implement that, how to actually make that happen. So the thesis statement of this talk is, through a series of remarkable policy documents and laws, South Africa has formulated a visionary holistic approach to the human right to water and to water security for present and future generations. This is a uniquely South African approach to the public trust doctrine that marries equity to ecology to fulfill the human right to water, and the challenge remains to implement that vision. So now I will spend the rest of the time explaining what I mean by this. So, first of all, on the human right to water, South Africa started off by getting it very right, then took a few wrong turns, and now seems to perhaps be on the pathway to getting it right again. So, globally, we know that over 1 billion people lack access to safe, clean drinking water. According to the World Health Organization, that would mean stand in front of that, greater than equal to 50 liters per day within 1 kilometer of your home, costing less than 3% of your family household income. We also know that about 3,600 people die every day from ill health coming from inadequate or unclean water. This is about 3% of total deaths and about 15% of childhood deaths. In South Africa, after the end of apartheid in 1994, more than 20 million South Africans, about 59% of the country, did not have access to safe, clean water. And now, we still have about 3 million people who lack access to safe, clean water, but they've moved up to about 95% of the population does have access to what South Africa refers to as fulfilling the human right to water. We will talk a little bit more about what that actually means in South Africa terms. Now, South Africa is illustrative and important when we're looking at developing countries attempting to implement this right, because if you can do it in South Africa, you can do it anywhere. South Africa has very few rivers. There is no mountain snowpack. There is low annual rainfall, less than the world average. South Africa is the 30th driest country in the world. There is seasonal variability. It rains for some parts of the year and then it is dry for many, many months. South Africa suffers from droughts, and which are now being exacerbated by climate change. The average temperature increase in South Africa over the last 50 years has been twice the global average, due to apartheid. Human settlements, where most of the people live, are built far from water sources. They're built around mines and other places where people were put to work. So there's a mismatch of what water resources there are to the population centers, and water rights were traditionally linked to land ownership, which was, for many decades, limited to white people in South Africa. Furthermore, irrigated agriculture uses more than half of the water, about 60% of the water. Those corporate agriculture sources are mostly owned by wealthy white people. Finally, we're trying to institute a human right to water, and that tends to run into a different ideology. Starting around the time at the end of apartheid, water came to be seen by international donors as an economic commodity. Managing water as an economic good is an important way of achieving efficient and equitable use and of encouraging conservation and protection of water resources. That is to say, even if, on one hand, water is a human right, on the other hand, you can't just give it away. So when South Africa was trying to rebuild in the 1990s, they went to international financial institutions, they went to the World Bank, and the World Bank was going to put conditionalities on all loans for South Africa. They had to impose fiscal authority, reduce spending on public projects and services, access domestic markets by foreign interest, privatization of state-owned businesses. So if you're trying to provide a source of basic water to your people, and at the same time, the only way you can get loans for development is to privatize, you're going to run into some tensions. In the international human rights parlance, there's two different fundamental kinds of rights. There are civil and political rights. These are things that countries are supposed to realize immediately. Freedom of religion, freedom of press, non-discrimination. Water, the right to water, is classified as an economic, social, and cultural right. In international human rights law, this means nations are required to progressively realize the right, to take steps within available resources to respect, protect, and fulfill that right. And we see that reflected in Section 27 of the South African Constitution, where the nation is supposed to take steps within its available resources to achieve the progressive realization of such rights. What's at stake in South Africa is what available resources actually are and what progressive realization actually means. So, to put the right to water into action, South Africa put forth laws and then policies to implement the laws. The National Water Act is seen as the world's most progressive water law by many sources. And there are 8 different planks of how the human right to water is going to work in South Africa and how water is going to be managed. First of all, in 1997, the National Water Act unearths South Africa's public trust doctrine, which had been buried during the years of apartheid. Water is supposed to be controlled by the public interest, a common good. It's the foundation of the new water law. The government is not allowed to give away the water sources and has a duty to regulate water for the benefit of all South Africans. For those of you who've never heard of the public trust doctrine, it is a hoary document dating back to the Holy Roman Empire about 1,500 years ago, where we believe that some of Earth's resources should never be sequestered for private use. They have to remain in the public's beneficial interest, for the public's beneficial use, and the resources are supposed to be stewarded sustainably by those in power, and the public has a right to demand that its trust resources, like its water resources, are stewarded sustainably. So this is the cornerstone of South Africa's new water laws. South Africa says the idea of water as a public good will be redeveloped into a doctrine of public trust, which is uniquely South African, and that is going to be a doctrine that grounds the public trust in equity considerations. Second provision, water has to be controlled and governed by fair and equitable access. The duty is to regulate water for the benefit of all South Africans to be beneficially used in the public interest. one of the cornerstones and one of the revolutionary things about South Africa's founding water law is that we must maintain an environmental reserve. That you have to fulfill the public trust by maintaining a reserve that fulfills human needs and protects aquatic ecosystems. When the needs of the environmental reserve cannot be met because of existing developments, provision must be made for active intervention to protect the water resources. So not only are we committing to providing free basic water to every citizen, but we're also committed to maintaining an ecological reserve. South Africa considers that you can reallocate existing water rights. Many of those water rights were impermissibly given under the apartheid regime. The national government has in its power, the capacity as public trustee, to reconsider previous water allocations. So if you have water now, that doesn't mean you're going to have it tomorrow if the government feels that it would be beneficial to redistribute those water rights. Because of progressive realization, the right to water isn't something that everyone can claim immediately, but water is going to be limited. Even though the World Health Organization says basic water is 50 liters per day, South Africa has defined it as 25 liters per day, or 6,000 liters per household, within 200 meters of a house. 25 liters, for those that can't visualize that, is about 2 toilet flushes of water. And the government isn't going to give it all away for free. The way it's been defined is every person is entitled to 25 liters per day for free, and if you want more than that, or if you want it delivered to your yard or into your home, you're going to have to pay. And if you don't pay, your water will be shut off. And as part of World Bank conditions, the government sometimes farms out water provision to external companies, foreign companies. That is to say, if the government feels it can't provide water, it will outsource water provision. By the public trust doctrine, the government can't give away the water itself, but it can give away the provision of water to foreign companies. So, public trust doctrine, fair and equitable access, an ecological reserve that for non-human species as well as to provide for human needs, reallocation of existing water rights, progressive fulfillment according to available resources, limited water per person, limited free water per person, and the possibility of privatizing water delivery. South Africa, in the early days of the Constitutional Court, is seen as one of the most progressive countries in defining what counts as economic, social, and cultural rights and what a government has to do to deliver those rights. There are 2 famous cases. If anyone here has taken international law or international human rights law, you may have read these cases from South Africa. In the government of the Republic of South Africa versus Irene Grootboom, a group of very desperately poor people invaded vacant land, took over land, and set up settlement. And when the government attempted to kick them off, they sued the government. And when the Constitutional Court found that the Constitution obliges the state to act positively to ameliorate conditions. The obligation is to provide access to housing, healthcare, sufficient food and water, and social security to those unable to support themselves and their dependents. The state must foster conditions to enable citizens to gain access to land on an equitable basis, and those in need have a corresponding right to demand that this be done. This may not seem revolutionary, but because many developing countries have all kinds of beautiful language about economic, social, and cultural rights in their constitutions, that doesn't actually mean that those get operationalized or realized in the real world. So the court says, I'm conscious this is an extremely difficult task for the state to meet. This is recognized by the Constitution, which expressly provides that the state is not obliged to go beyond available resources is to realize these rights immediately. I stress that, however, despite these qualifications, these are rights, and the Constitution obliges the state to give effect to them. In other words, the words in the Constitution are not just words on the page. They mean what they say. And also, rights have to be filled progressively according to the means of the government. But the government can't simply say, well, we don't have the resources, or we're doing the best we can, if a court finds that they're not doing enough to fulfill the rights and they actually have more resources than they claim. Second case, Minister of Health versus the Treatment Action Campaign. There is a medicine that prevents HIV transmission from mothers to infants, and the Constitutional Court found that denying certain women that medicine violates the right to health in the Constitution. Let's move on to the right to water then, coming from these precedents. The right to free basic water is not an absolute right. Abuse of the right to free basic water can result in the restriction and or disconnection of the water supply, provided fair and equitable procedures are followed and special arrangements for indigent persons are made. With that policy, Mrs. Masibulko and other plaintiffs living in Soweto, one of the all-black townships of Johannesburg, sued the government saying that 25 liters per person per day was too little, that in fact the formula that the government used to figure out how many people live in a household was miscalculated, and that having water meters that you have to prepay and that disconnect if you don't pay violates the fundamental right to water. Here's a communal standpost. If you can't afford to have water delivered to your home, you go to a communal tap. This is a prepaid water meter. This is what something like this looks like. This is in Soweto. You have a key, and the key gets recharged when you've paid your bill. This is a standpost in a home in Soweto. Johannesburg Water monitors these, and this is to whom you have to pay if you want more than your 25 liters per day. In what was seen at the time as one of the most progressive decisions on an environmental human right, the trial court in South Africa found that the government had the means to provide twice the amount per day without restraining its capacity on water and its financial resources. The fact that in Soweto, poor black people had to prepay, but in the wealthy white suburbs, people did not have to prepay, and if they did have water meters, they didn't shut off without notice, was found to be unconstitutional. Patronization sustained apartheid. Its foundational basis was discrimination based on color and decisions taken on behalf of the majority of people, as Big Brother felt it was good for them. This is discrimination solely on the basis of color. That's impermissible in the terms of Constitution. The judge also found that because women and girls did most of water fetching for families, that this was discrimination based on sex. This was appealed. There were 3 layers of appeal. The Constitutional Court decision is the first time a highest court of any nation has considered what counts as the right to water. Other constitutional courts have found a right to water in the first place. India, for example, is one of those courts that found that the right to water is embedded in the right to life of the Indian Constitution. But this is the first time a court has had to think about, well, what do we mean by a right to water, and what does a government actually have to do? The Constitutional Court ends up overturning the trial court's decision. They find it is institutionally inappropriate for a court to determine what the achievement of any particular social and economic right entails and what steps the government should take to achieve the right. Again, the court looks at what's reasonable for the government to do and what counts as available resources. If a government does nothing to fulfill the right, the court will overturn it. If those measures are unreasonable, the court will overturn it. The government has to continually review its policies to ensure that the achievement of the right is progressively realized. And the court finds, to the dismay of human rights activists around the world who were looking at this as an international precedent, that the government was doing what it could to provide 25 liters per day, and that it was in fact not discriminatory for poor people to have to prepay for their water and to have it turned off without notice. This was widely greeted in the international human rights community as not a particularly good thing. So, in analyzing this, I'm going to talk about why they might have gotten this wrong and what South Africa has done since then. First of all, experts at trial talked about the fact that about 40% of the water in Soweto is simply wasted through leaks and outdated infrastructure. And there's lots of different technological remedies that the government could have taken. Furthermore, You can go to the poor communities in Soweto, and then you can go to the wealthy neighborhoods elsewhere in South Africa and see gluttonous uses, swimming pools, and the like. There is a paradox about pricing water, which is that once you privatize water, once you outsource water, there is incentive for the providers to encourage people to buy more water, to use more water. And the tariff system in South Africa did not penalize gluttonous water users. There was a flat rate over and above the 25 liters, which neither encouraged conservation, nor did it appropriately price things so that you could cross-subsidize poor people's use of water. Water meters can be made that give you notice before they're going to be disconnected so that you not suddenly are without water. Furthermore, the possibility of reallocation of water rights has been possible. The Constitution and the National Water Act anticipates this. Particularly, 60% of the nation's water goes to irrigated agriculture. That is almost all given away for free, and it provides about 7% of the nation's jobs and about 3% of its economic activity. So there is a possibility that some of that water could be reallocated for human use. And we know from the white paper, but also from Section 25 of the Constitution, that that is legally possible. Finally, the idea of water as ecological infrastructure was never argued in this case and was never considered by the court. So what do we mean by that? Here, we're in the hills above Stellenbosch, South Africa, north of Cape Town. This is the Jonkershoek Preserve. That's preserving the water source for the community of Stellenbosch. From the National Water Resource Strategy, which I'll talk about in a second, water is a precious resource in South Africa and is fundamental to our quality of life. Healthy water ecosystems are imperative to sustain the water resource, which in turn provides the goods and services on which communities depend. The indivisibility of water is a cornerstone of the national water policy, to the extent that water ecosystems are not seen as users of water in competition with other users, but as the base from which the source is derived, without which growth and development cannot be sustainable. So, if we think about water as ecological infrastructure, it encourages us to ask how much progress actually counts as progressive, what exactly are the available resources, and can you actually supply a minimum core of water that is more than the 25 liters per day that the government is currently willing to give out for free? The courts also never thought about or considered or talked about the public trust doctrine, about stewarding and not squandering the resource. And so to reconsider what counts as available resources means looking at what the government is actually doing to steward that resource. Even though we know that a cornerstone of the water law in South Africa is the ecological reserve, neither the lawyers argued about sustaining the reserve, nor did the court actually consider that. We know that you fulfill the public trust by retaining the reserve that fulfills human needs and protects aquatic ecosystems. So, finally, the government now is on its way to thinking about water differently. Again, having made mistakes during about the first 15 years that they've been considering the human right to water, through the National Water Resource Strategy, which is required by the National Water Act, and by a program to think about ecological infrastructure for water security, the government is coming to see that maybe available resources are not static. Maybe we can maximize our resources if we manage the ecological basis of that water. This map shows where, on the left, we see ecosystem services. Where are we providing, where does the water in the country come from? The darker green are the sources of water. And you can see that maps pretty well onto the poorest parts of the country. So there is an idea that if we can employ people and pay people to steward the ecological resources, we might both maximize our water sources and also help to alleviate poverty. So here we have the National Water Resources Strategy. And the government freely admits that equitable access to water is critical to transformation in the water sector. Little has been made on the National Water Act Pillar of Equity. And the government plans to do something about that. Special attention must be given to the needs of those who are historically denied access to water, and the government is now contemplating finally reallocating water, which its constitution permits and the National Water Act allows, particularly for black and women users. Finally, they've started to institute compulsory licensing. As the public trust requires, you have to show that your water use, if you are one of the big water users, is actually being done in the public benefit, and that you did not impermissibly receive that allocation in the first place under an apartheid regime. So the indivisibility of water, again, the cornerstone of the national water policy, to the extent that water ecosystems are not seen as users of water in competition with other users, but as the basis from which the resource is derived, without which growth and development cannot be sustainable. So how do we maximize our available resources to fulfill the human right to water? How do we marry equity to ecology for a win-win situation? We know that the reserve has the highest allocation priority. So the first objective, ensure that sufficient quantities of raw water are available to provide the basic water needs of people, as well as maintaining healthy ecosystems, but seeing those things as inextricable in a way that they are not in competition with each other. Only through managing the ecological reserve can you fulfill the basic human needs. And this is what South Africa is striving to do now. And one of the ways that they're doing it, the government is in the process of a major campaign to improve the nation's infrastructure. And one of the ways that they're going to do that is thinking about ecological infrastructure for water security. They're spending about 2 billion rand, which is about every day the rand drops in value, but that's about $150 million on 360 projects focusing on the 8% of the country that provides 50% of the water reserve. The idea is if we can employ people to manage these ecosystems, to manage grazing, to clear invasive weeds, etc., we can actually come up with more water resources. Sound ecological infrastructure underpins healthy watersheds, does much the same work as a water treatment plant and other built water quality infrastructure without the expensive equipment and associated operating costs, and with added benefits like protection of wildlife habitats and carbon sequestration. Watershed services, trying to maintain the watershed services and employ people to do that maintenance. The goal that South Africa, at least on paper, is now aiming at says, dedicating water to the reserve and protecting that source doesn't compete with human uses. In fact, it's the only way to sustain a growing human need. This is the human indivisibility of water. South Africa has currently used about 98% of its available water resources, and the need for water is expected to grow 30% by 2030. The only way that they're going to be able to do this is to find more water, which means managing their ecological water resources. Failing to do that is squandering the resource and violating the public trust, which is the cornerstone of national water law in the country. And there are pilot projects. Durban, which has essentially run out of water, their water managers now have pilot projects where they are measuring how much more water they are getting by managing their upstream ecological infrastructure. And this is convincing the government that you actually can maximize your water resources, that available resources in water are not static, they can be grown through sound ecological stewardship. So, after getting the right to water wrong, or after getting it right, and then getting it wrong, South Africa seems to be on the path to getting it right again. Again, there's some criticism here, but they are building the bike as they're riding it. They are doing this in face of very difficult conditions in South Africa, and they are looking for a uniquely South African approach to the public trust doctrine that sees stewarding resources in a way that marries equity and the human right to water to ecology, to sustaining the ecological reserve. That is the only way you can actually fulfill that human right. That these are not necessarily in conflict, in fact, they are fundamentally intertwined. So, to conclude, The uniquely South African approach to the public trust doctrine marries equity to ecology to fulfill the human right to water. The challenge remains to implement the vision. In questions and answers, I can talk about why this might actually happen and it's not just a pipe dream. And thank you very much. I don't know how to get to. Are you yes, what? Just turn this off.
Yeah.
Good morning. Thank you for having me. It's a great pleasure to be here. In 2010, a massive earthquake struck Haiti, about 30 kilometers west of Port-au-Prince, the country's capital. Wasn't from a seismological point of view the biggest earthquake that we've seen on record. It was significant, but the country and the capital were leveled largely as a result of Port-au-Prince's vulnerabilities. If you've ever seen a picture of Port-au-Prince, you know that it's set on steep slopes in the mountains, that its infrastructure is dominated by concrete blocks. So these largely fell down, creating really a human or man-made catastrophe of epic proportions. In the days and weeks after the disaster, money was said to be pouring in. In fact, much of it was pouring into accounts of foreign agencies and donor organizations that still have not spent what they have committed to spend. But one of the themes that came out of many of those discussions was to build back better, or to use the opportunity of this disaster to build Haiti back again and to build it better. One of those strategies, when the Inter-American Development Bank, USAID, the U.S. Agency for International Development, some UN agencies came together, was to try to diversify Haiti's economy, so try to move some activities away from the capital where much of economic life was being conducted. So they decided to build a large industrial park. And they were going to put the industrial park in northern Haiti along a small river called the Trou-du-Nord, about 30 kilometers east of Cap-Haitien. They eventually did build the industrial park. There's now a large paint manufacturing plant. They're still trying to attract more investors there. But they built it and quickly, soon afterwards, a few years ago, realized they hadn't properly considered what the implications might be on building a large industrial park with respect to water resources. They didn't know, for example, what impact this would have on the river, on the coastal estuary, and on the coral reefs that the river spills into. And conversely, they didn't know if they would have a source of fresh, clean water to use for manufacturing. So they hired Florida International University, where I teach environmental and natural resources law, to conduct a study about this. Really, I've been focusing for the past couple of years on the institutions in Haiti, both locally in northern Haiti and in the water sector as a whole. And last summer, I concluded my study, and it was kind of different in terms of legal research. I wasn't really sure what to do with this. Some colleagues told me, some political science journals would love this, or maybe some geography journals. And I said, but I'm a law professor. I'm a legal scholar. I'm going to try to see if maybe a law review would be interested in this. And sure enough, a law review sort of quickly jumped at the chance to work with me in editing the study. And that was the Tulane Environmental Law Journal. So it's been a pleasure working with Tulane, and I was really impressed with their enthusiasm that they had for research in Haiti, and really that line of sort of out of the box legal law review work in general. I'm going to talk to you about that project and about the water sector in Haiti. But before I do, I want to give a general overview of water rights in the international or transboundary context. I was reading The Economist, the latest issue of The Economist, on my plane ride over here yesterday. And in this issue, they had a 10-page spread in the middle about the Mekong River. The Mekong River flows in Southeast Asia and sustains millions of livelihoods there. And they were criticizing many of these governments for their lack of cooperation and coordination. Essentially, every country that the Mekong flows through now has massive plans to build hydropower plants. They want to create energy, and they're not really considering or appreciating the consequences that will have both upstream and downstream. A part of the frustration here, and The Economist doesn't really touch on this, is that there are no hard and fast rules about how countries are supposed to share water resources. So upstream countries, notably China, are planning many dams in the next few years. And every downstream country saying, well, if they're going to do that, I might as well do it too, are also coming to the same conclusion. Individually, some of these dams might not have devastating consequences. But when you consider the cumulative impact of creating dozens, if not hundreds of dams on a major waterway, you're going to dramatically alter the course of that river. We know that well, right? The Mississippi River is really nothing like what it was in the early 1900s. They had a quote in here that says, "It is the way of rivers, those downstream bear the cost." Technically, that's not supposed to be true. In 1997, the United Nations member states came together and hammered out the Convention on Transboundary Watercourses. And the convention included two major principles intended to articulate how countries are supposed to share transboundary rivers or watercourses, including lakes and aquifers. One of those principles is the principle of equitable use, essentially reasonable use, right? A country, if they have access to a water resource, has a right to utilize it in some way, to make some benefit out of it. But conversely, there's also a principle that a country cannot create significant harm on a downstream state. So you can't use that resource to the point of detriment to other countries. Anybody tell me how to reconcile these two principles? On the one hand, you get to use the resource. On the other hand, you can't harm downstream states. You can easily see a situation where someone might create a dam, for example, to generate energy and provide that energy to its citizens, perhaps create an irrigation scheme. That's going to have downstream impact. It's going to create significant harm on a downstream state. The convention tries to reconcile this by including a third principle of cooperation, that states have an obligation to cooperate and to figure this out. Now, the intent here was noble and I think valid, right? When you're talking about natural resources, we often say natural resources law is place-based. It wouldn't have been sensical for the UN to come up with a very specific scheme of allocation, generally applicable to all the world's waterways. So their intent was good. There wasn't a lot of enthusiasm for the convention afterwards. It passed quite quickly at the time. Of course, it needs to be ratified. And it wasn't ratified. They only needed, I believe, 35 instruments of ratification for the convention to enter into force as a binding treaty. That didn't happen until 2014. So just about a year and a half ago was when the UN Convention on Watercourses entered into force. We still don't quite know how it is supposed to operate. It overlaps with some other treaties, notably the UNECE has a water convention for many of the UNECE countries, the United Nations Economic Commission for Europe. They have their own water convention. Some of its terms are slightly contradictory to the UN Water Convention, the United Nations Water Conventions Treaty. They came up with a draft law on transboundary aquifers. So the UN Watercourses Convention, doesn't deal with confined aquifers. Confined aquifers are groundwaters that are not hydrologically connected to surface waters. It's not clear why they excluded these. It's believed that perhaps many of the countries that have confined aquifers didn't want the treaty to address those issues or didn't want it to have jurisdiction. But because of that, they've created a law on transboundary aquifers. The problem is that the law of transboundary aquifers encompasses both confined aquifers and unconfined aquifers that are governed by the United Nations Watercourses Convention. And the law on transboundary aquifers introduces a fourth principle of international water law called territorial sovereignty, essentially saying that if you have groundwater underneath your territory, you have sovereignty over that groundwater. So now we need to reconcile territorial sovereignty with the principle of equitable use and the principle of no significant harm. And it's been pretty challenging to do that. In addition to the Mekong, one hotspot for water issues in the past few years has been the Nile River Delta. So you may have heard that Ethiopia is building a large dam to provide electricity to the country and the region. And Egypt, the downstream country, has vehemently objected to any type of upstream use. And this largely stems from treaties dating back to colonial days when the Nile, when Egypt was given essentially the full flow of the Nile's waters. So there was a treaty between Egypt and Sudan in which they essentially agreed that Egypt would have 90% of the Nile's flow and Sudan would have the remaining 10%. You can imagine how Ethiopia and Tanzania and Rwanda and Uganda and Burundi feel about this treaty. Essentially, two countries deciding, no, we're gonna declare as a matter of international law this river belongs to us. Understandably, those countries have been asserting their right to equitable use. They've been saying, especially Ethiopia, we have a right to use this river. You can't allocate all of the water resources, all of the flow down to Egypt. And Egypt, unsurprisingly, has been emphasizing the principle of no significant harm. They've been saying, well, whoa, you're the upstream state. You have an obligation not to cause significant harm to this massive hydropower project. You know, I'm sorry, but that's gonna create significant harm. And it's not clear how these are supposed to be reconciled. The Nile countries have come up with a framework cooperative agreements. Their principle that they introduced was water security. So no country can take an action that would jeopardize the water security of another state. But it's not clear what that means either. Egypt has been saying water security means no significant harm. And Ethiopia has been saying water security means equitable use. And it's really, observers are not clear on how this will proceed, how this will move forward. Ethiopia and Egypt did sort of sign kind of a transitional cooperative agreement a few months ago that a lot of people took as a good sign, but it did not articulate adoption of one principle or another, or sort of confirmation that Egypt would be fine with how Ethiopia continues to process and operate the dam. Really what's important here are institutions. In the Mekong River, The Economist mentions that there is Mekong River Basin Commission. And why aren't they acting, and why aren't they trying to resolve some of these issues and look at the cumulative impacts of all this hydropower development? Well, for one thing, China's not a member. You can't compel countries to be part of some of these commissions. And they also don't have very significant power. So that's the case, and that was a major finding that I saw in Haiti. So in Haiti, we have a plethora of institutions on the national level that all deal with water resources. We have the Ministry of the Environment, which is, on paper at least, has jurisdiction over water resources, the right and ability and sort of responsibility to manage water resources and work with local governments to do so. We also have the Ministry of Agriculture. The Ministry of Agriculture has the right to manage irrigation water, and it has interpreted its role or its authority much broader than irrigation water. It came out with a water management policy in which it sort of, in a self-serving way, sets the Ministry of Agriculture up to be the water authority in Haiti. There's no real resolution. The Prime Minister, the President, the courts haven't stepped in to say, you ministries realize that you're both trying to manage water resources, right? And so they're both proceeding under that assumption. In practice, the Ministry of Agriculture is more powerful, it's more well-funded, it has more staffing, it gets more support from international donor agencies. Ministry of the Environment, relatively, is weaker staffed, has fewer resources. So while it has more of a statutory authority to manage water resources, it's the Ministry of Agriculture that really has the power to do so. Then you've got a third ministry, the Ministry of Public Works, which manages water supply, sanitation, and hygiene, or WASH. WASH services in Haiti are pretty dismal. Most people don't have access to improved sanitation facilities. And so there's a huge challenge there for the government to try to address these issues in a sustainable and integrated way. enter a new institution that was created with the help of the Inter-American Development Bank. This is a coordinating body. And their sort of mandate is to coordinate between all these institutions how they're going to manage water resources. On paper, they appear to have authority to manage water resources themselves as well. So now we have 4 institutions that can manage water resources in Haiti. In practice, not much is being done. This fragmentation is leading to a lot of confusion and sort of diffusion of responsibility. Ministries want to sort of have the power to exert authority over water resources. They also don't want the responsibility of actually having to do it. And should be said as well, there's a huge resource gap in Haiti. Many of these agencies, even the Ministry of Agriculture, which is relatively well funded, don't really have the financial or human resources necessary to succeed in some of this integrated water resources management, which can be heavily resource intensive. Complicating the matter a bit further is the fact that Haiti passed a decentralization decree. So this is a pretty popular notion in the concept of integrated water resources management today. The idea is that you should manage water resources at the lowest appropriate governance level. So if you have one local jurisdiction that encompasses an entire resource, that resource should be governed at that local jurisdictional level, not at the national level. Right? If you've got a major waterway, a major river that crosses all these provinces or jurisdictions, then yes, that should be managed at the national level. That's often been interpreted to mean we should just decentralize. We should just manage water resources at the lowest possible governance level. And that's essentially what has been asked of many of these municipalities. In Haiti, they're called sections, communes, and departments. A section might be tasked with managing a particular waterway, when in fact they have no staff to do that with. They literally do not have an office. They don't have a truck or any type of water monitoring equipment. They don't have any paid staff other than maybe one representative who attends commune meetings. The commune is a little bit better staffed. They might have one paid representative and perhaps an office that they share with other communes within the department. But you can see how this sort of creates a situation where all these ministries and these local governments believe that somebody is responsible for managing water resources when in fact that's not the case. So take, for example, the Twidunel River Basin in northern Haiti, which is this large industrial plant that the Inter-American Development Bank has been supporting. There are 4 communes there, and they largely don't have capacity for water resources management. When I spoke with them, they said that they might be able to talk with community members about certain best practices, not putting pollution into the waterway, that kind of thing. The Ministry of Agriculture has a presence there in monitoring farmlands, largely an agrarian region. The Ministry of Public Works also has some staff tasked with providing water supply and sanitation facilities. But again, they're very focused on these specific mandates. The Ministry of the Environment is non-existent in this region. It has literally no representation in the Twidunel River Basin. The Inter-American Development Bank came to me and said, okay, well, if we were to create some kind of institution to manage water resources in this basin, what would it look like? Or what should it look like? I said, well, there's a lot of great ways, a lot of great ways you could create a robust institution that would manage water resources here. Right? You could use an existing agency and really articulate, its duties and task it with management of this agency. You could create a public-private partnership. You could create a commission. And they said, okay, great. And we can do that with existing resources? I said, no, you can't do it with existing resources. You have to invest. And therein lies one of the greatest challenges in Haiti and in many countries around the world. As you can see, it manifests itself in many different ways, right? The Nile River has a commission. It's poorly staffed. It doesn't have robust legal jurisdiction. The Mekong River Basin Commission doesn't have China as one of its members. It doesn't have much power. You can create an institution, you can create a commission, you can say that it's undertaking sort of integrated and interagency water management, But if you don't vest it with the appropriate financial and human resources and with the appropriate legal authority to really carry out its mission, you're just creating another layer of bureaucracy and of paper that's really not accomplishing or significantly managing water resources. That's what I found in Haiti, and I'm excited to keep working with the Tulane Environmental Law Journal to bring that out in public. Thank you very much.
At this time, we'd like to open it up to questions that you may have for David or Ryan. We hope to generate some really good discussion. So,
Yeah.
How does wildlife and fisheries resources fit into the concept of managing water?
Yeah, it's a great question. Water is a multiple use resource. In the context of Haiti, fisheries is a huge issue as well. They're out fishing many of their coastal areas. They're trying to address that by passing legislation. But again, you sort of see the same manifestation with respect to fisheries and wildlife that you see with freshwater resources. You've got a law on the books, but no one's actually implementing or enforcing it. And that's a huge challenge in a country like Haiti.
David? So when you're talking about ecosystem services and South Africa is increasing emphasis on them, are they seeking to cost those out and place some kind of value on it and create a market-based approach?
There is the government has just put out a major document on exactly that, a coordinated environmental services trading mechanism in water, biodiversity, carbon, so to try to have some kind of coordinated approach, exactly what you are saying right now. And one of the interesting things that's happened with the sample management for ecological services in the Durban headwaters is they've both priced out what the services are, what it's cost them to manage it and to increase the available resources, and then they now can say how much extra water they have gotten out of those headwaters that they would not have gotten otherwise, and how economically efficient that actually is, as an example of trying to actually put numbers on it that would be exemplary for the rest of the country.
sir, I think we're next.
Hi, I've got a question. One is on the Haiti thing. In the UK, we had difficulty with integrating with the basin management kind of drawing the boundaries along the watershed jurisdictions and having the same body that managed the abstraction also managed the sewer and aquatic outflow. So I wonder if there's been any.
Yeah, it's a good question. There has been some movement to essentially redraw jurisdictions along those resource boundaries. I teach environmental law in Florida. In Florida, we have a pretty progressive and robust water management system in which we've redrawn political boundaries according to water resources. So I live in the South of Florida Water Management District. We have several other water management districts that have authority to manage sort of an integrated perspective on water resources. So public supply, agriculture, groundwater use, ecosystem services, recharge. They look at all aspects of water management. That's a pretty good example of subsidiarity or decentralization of water resources management working well. Although they still have challenges, and one of the major challenges they have is this same transboundary issue. So many people would like to see water moved from northern Florida to southern Florida, where there's a lot more people. Northern Floridians are vehemently against that idea, and that's not uncommon. People are usually sort of have very passionate responses when you try to take water resources away from their area. So this transboundary issue remains a problem even for a situation in Florida where we have water management districts that are well funded and have been authorized to look at water from an integrated perspective.
Just one question on the other, which was, I'm thinking about the food situation, has the rights to water quality come up as well as water quantity?
Yes. So the nation has definitions of what counts as water quality as well. That seems to be less of a concern, or at least in my research and talking to people, it seems to have been less of a concern that the water that actually does come out of the pipes is okay. So that has been not litigated.
Yeah, I saw a couple of weeks ago there was a legislator in Michigan that proposed a bill that would establish a human right to water in the state of Michigan, which I thought was pretty unique, pretty interesting that would sort of be a possible outcome of the Flint water crisis. But then I saw them interviewed and they said, does this bill have teeth? Well, probably not. But, we think it's a good idea to establish the principle. I was like,
Two years ago, California legislature passed the human right to water in California, but no one knows what meaningful work that actually does, because the United States tends not to speak the language of human rights. 6 states in their constitutions have a human right to a clean, healthy environment. Mostly courts have found those non-justiciable, that is to say, until the legislature actually does something with that, it's kind of meaningless. Although Pennsylvania is kind of an interesting state where actually things have happened as a result of that, but that's one very isolated example of how human rights to whatever the environmental right is actually works in this country.
Yeah. Green.
Thank you. Well, that relates to what I want to find out. South Africa, I believe, is allowing hydraulic fracturing, and South Florida is debating it now. With all the high water use and poisonous outcome, how are they, what's the future of water?
Do you want to know about South Africa or Florida?
Yes.
Again, as Ryan was explaining, you can have competing ministries competing for power and at cross purposes, like we do in our own country. In South Africa, that's a particular problem. The fracking problem right now is the hotbed of what happens to thinking about the human right to water, thinking about what happens to water quality. It's a test ground for what the human right to water actually means and whether they're serious about ecological infrastructure to start with. But the interests are so powerful in South Africa to do fracking, in part because it's about a few years ago in South Africa, due to extensive mismanagement, essentially the electrical power grid has failed, and so just about everywhere in the country for at least 2 hours a day the electricity goes out, which is seen as the greatest threat to the stability of the African National Congress, because if you can't deliver electricity to your people when you used to be able to, you're doing something fairly wrong. So the drive for fracking to supplement power is really, really strong right now. So you've got a lot of competing things going on, but fracking is definitely on the table all over South Africa.
Yeah, it would be particularly problematic in Florida based on our geography. The Florida Peninsula is made pretty much entirely of limestone, which is a very porous rock material that allows water or other fluids to pass very easily and very quickly. So because of that, we have fantastic groundwater resources. We have very clean water, we have very plentiful aquifers in Florida. But if you were to sort of mess with that system or introduce outside chemicals to that system, it would move very quickly and very broadly. So one problem that we're already dealing with is sea level rise. As sea level rise is occurring in South Florida, we're dealing with saltwater intrusion that's really spoiling a lot of our fresh water, a lot of our aquifers. In Miami-Dade County gets most of its water from the Biscayne aquifer, so we get most of our water from underground sources. And so we're deeply concerned about and worried about saltwater intrusion that can have a massive impact. I know we're moving towards, and there's been some friendly overtures towards fracking in Florida, but I think from a public perspective, and we're a fairly conservative state, but people in Florida, in my view, are pretty considerate of their natural resources. People like to have clean water. We like our beaches. We're sort of from a local government point of view, progressive when it comes to climate change. Miami-Dade County politicians are keenly aware that the threat that poses. So I'm not sure how extensive fracking will end up being in Florida.
We're gonna over here.
I had a question for you about Haiti or island nations in particular struggling with water infrastructure, like potable water, sanitation, like you mentioned. because of that, is there like a dependency on privatized bottled water coming in? And if so, what sort of impact does that have on the community? Like, I know like plastic in heated environments can like leach chemicals into the water. Does that play into like health impacts, or also like not having the proper infrastructure to like manage a lot of the plastics that might be coming in? I know in the Bahamas that's an issue. I'm wondering if Haiti has the resources for like the importation of bottled water, and if so, like, I don't know, like what is that an issue there?
Yeah, it's certainly a very important issue for island states, and especially in the Caribbean. Some of the really small island states do just import water. I know the Bahamas has some limited groundwater reserves, which is pretty interesting. But for the most part, Haiti, which is on the sort of shares an island with the Dominican Republic, they don't have so much of an absolute water resource deficit as much as it's a management and policy issue. It's just not managed very well. The rivers are very polluted. There's a lot of fertilizer runoff. There's not a lot of access to clean water or sanitation facilities. It's definitely a resource issue. I think importing water would be, I don't know who would fund that. So it would certainly have to be an outside organization, a donor organization. They often do it in cases of humanitarian situations right after the earthquake that certainly occurred, but from a long-term perspective, it's not really sustainable, and it's not necessary in Haiti. Because again, they've got the water, you just need to figure out ways to more effectively manage it.
I have a question about South Africa. What has been the response to the ecological stewardship from the targeted communities?
The targeted communities being the downstream communities, the urban communities that don't have the water, or the communities around the headwaters, the sources?
Both, I guess.
The headwater, at the headwaters, it's seen as a source. It depends on who you are. For some people, it's a source of income. South Africa has a program called Working for Water, where they've employed about 30,000 people, mostly doing clearing of invasive weeds and doing other kinds of management like that. It's very basic employment, but it is some employment in places where there are not other sources of employment. If you're at the headwaters and you're a farmer who doesn't want to be told you can't graze your cattle or grow crops within a certain amount of distance from these waterways, you might have a different opinion about water as ecological agriculture. Water as ecological infrastructure. Downstream in the communities, I don't believe that this is a concept that registers necessarily. What you care about is there something coming out of your tap, and is it going to cost me any money? And however it gets there, it gets there. So I don't know if that's the answer you're looking for, but.
David, I'm inferring from what you said that you have some issues with World Bank agreements conditioning uses of water. What specifically are your objections, and what would you propose that the World Bank do instead?
The conditions as they play out in South Africa, there's a fundamental debate about, if you get it for free, are you going to waste it or not? So the World Bank says, look, you have to pay for resources, and you have to privatize to the extent possible. So in South Africa, they have outsourced, through these conditionalities, they've outsourced water provision to foreign providers. So for example, in the Johannesburg example, Suez Lyonnaise from France and Northumberland Water from Great Britain came in, and they were the ones that imposed some of the conditions that I was talking about here. They've all left because they found it impossible to actually turn a profit, because if you have to provide 25 liters per day for free with antiquated infrastructure, you're going to have a hard time turning a profit. But the philosophy drive behind that, the neoliberal economic philosophy, the government has adopted as well as part of the World Bank loan conditionalities. So even when it's government providers, they are incentivized to turn a profit on water delivery. The government cannot subsidize them, so they, even though they are a government entity, maintain the philosophy that people have to pay for their water. what I propose instead is that this is the fundamental debate about what counts as the human right, whether or not governments should be using some of their tax money to subsidize this, whether or not the 60% that's going to irrigated agriculture is really the best possible source of that water, whether or not you could, if you're going to take the philosophy of water should have a cost, you should at least price it appropriately so that you have cross tariffs, so that the very, very wealthy people who are gluttonously using the water are at least paying their fair share, so that the people that have no water can have their water sources. So I think I have a harder. This is a longer conversation than I can answer right there. So.
So, here in the States, kind of an example of what I'm hearing in South Africa happened in New York City. The New York City water, they basically said, okay, we could either build some major infrastructure, or we can try to protect the watershed, the Catskill watershed. But that also involved a lot of reservoirs and things like that. And so, are they talking about? Is it a similar model? And are they talking about the reservoir side of things as well?
It's funny because in every single South African water document, there are beautiful boxes with pictures about the New York City and the Catskills and how that all works.
Which they are having to install new treatment systems.
Right. So yes, they are talking about reservoirs, but before they're talking about reservoirs, they're talking about the more fundamental. 7% of the water gets sucked up by invasive weeds. Let's start with that. Let's start with not having cattle in riparian zones and causing erosion, which silts up the 4,000 existing dams in South Africa, many of which are on the verge of collapsing. So they're starting one step back and saying, let's just start with the basics. But they are talking about reservoirs and new dams and rehabilitating old dams, because they're going to have to do something to meet the 30% extra demand by 2030 when you're already out of water right now. So I should also add that one of the whereas New York City obviously is wealthy, one of the ways that this might actually happen is that South Africa is getting lots of money to do this from outside sources. World Wildlife Fund is incredibly interested. The UN Framework Convention on Climate Change's Adaptation Fund is funding some of the preliminary work. So as win-win wildlife biodiversity enhancing, but at the same time deriving more water from those places as well. So they have gotten a lot of international aid and more aid promised to do some of this work. So they have a source of funding for this in some way.
And New York also participates, and I'm really interested in institutional arrangements. They participate in the Delaware River Basin Commission, which is one of the models for how to set up a successful, functioning water commission. One of the ways they did that was they gave each of, I think, 5 different states have a vote in addition to the federal government. And certain actions require unanimity, but many don't. And so they can actually proceed without unanimous consent. A lot of these commissions that you see between countries or between states or jurisdictions, they'll be between 2 parties and each party has a vote, right? So essentially the commission doesn't do a whole lot. It's very difficult for them to overcome disagreements. But the Delaware River Basin Commission is a really good example of setting up sort of a governing body that can overcome challenges and disagreements and actually work on the ground.
Well, you know how that came into being was all the conflict among the various states, and they would sue each other in original jurisdiction of the Supreme Court. There are at least 3 cases called New York versus New Jersey. And the Supreme Court looked at itself as an appellate court. It was sick and tired of having to be a trial court. So on the third go-round, Oliver Wendell Holmes, you've heard the expression, a river is not an amenity, it is a treasure. That's from that opinion. And although he didn't say it in so many words, he said, right between the lines, if we see another lawsuit like this, we're going to stick you to the back of the line, and you could be waiting forever for a decision. But if you use the compact clause of the Constitution to do a multi-state and federal agreement, we look very favorably on that.
Yeah, the Supreme Court is so annoyed when they get water disputes in front of them. Very common in my state as well. We have an ongoing tri-state dispute between Georgia, Alabama, and Florida over the Apalachicola River Basin. Georgia created Lake Lanier for drinking water and sort of irrigation supply. Basically feeds or supplies Atlanta with drinking water, whose population has skyrocketed in the last 20 years. And that water does not, so that water no longer flows south to Apalachicola Bay, which supplies one of the largest oyster fisheries in the nation in Florida. So these states have been in disputes before the Supreme Court over and over and over again. Supreme Court over and over and over again says, figure it out. Come up with some kind of political solution, but we're still not there yet.
California, fortunately, has no problems with water or whatsoever.
Any other questions?
Question. On the international organizations encouraging privatization to the extent it's possible, given that water in many jurisdictions, including traditional common law and civil law, most surface waters anyway are either common things or public things, and they're not by law susceptible to privatization. How does that reality or that tradition, when it smacks into like international development agencies, we don't necessarily care about that?
South Africa has certainly, given that 1997, South Africa unearths its public trust doctrine. During the apartheid era, water was privatized. There's no question that people were able to allocate to take water, and they got water rights, which were seen as their rights forever and ever. 1997, with the revitalization of the public trust doctrine, South Africa has stood its ground and at least officially said, you cannot give away water. And if you think you have a water right, you really don't. It is revocable at any time. So they have never given away the actual water source since 1997. They've given away the right to deliver water services. So they've privatized the delivery, but not the actual resource. Now, many of the wealthy landowners in South Africa act as if the water is their private right, and South Africa now is undergoing the possibility, as I explained during my talk, of reallocating that water that was seen as impermissibly given. Section 25 of the Constitution allows that, the Water Act allows that. The problem is you also don't want to alienate your wealthy white landowners and then have the flight of white capital out of the country, which is in many ways sustaining the country. So the government is a little bit stuck there. So officially, water is not privatized. Unofficially, it still kind of looks like water is private, like that people own water.
Yeah, I mean, I think it's interesting from a broad point of view that the human right to water in many ways is a reaction to water privatization in the 1990s. That concept didn't really exist before this Washington Consensus created water privatization in a lot of developing countries. You had a sort of massive public protests and outcries all over the world once this happened, right? The idea is that privatization will provide the upfront capital necessary to make infrastructural improvements and upgrades. It'll allocate water resources efficiently. It'll do so where the market thinks it's most valued. The downside is that a lot of poorer communities were sort of priced out, right? Somebody else could pay more, so that's where the water would go. It was a very famous case in Bolivia where not only did they not have access to traditional water sources that they were using, they could no longer collect rainwater. So to tell the people that have been there for thousands of years that now you can't even collect rainwater, like that is owned by a private company, you can imagine didn't go over well. So this human right to water sort of stemmed out of that. There was pushback and people said, this is a sham, we can't continue to allow this. And the mechanism for pushing back on that is that we have a human right to water, we have a legal right to water, it cannot be privatized. As you said, international organizations, there's not agreement, especially many big donor organizations are not necessarily supportive of that concept. So there remains to be some debate, some issues when you're implementing some of these projects as to how much you can sort of do so on a human right to water paradigm.
Any other questions?
I want to follow up on with this question about the Bahamas and the pollution in the Caribbean region, especially Haiti, of course. And I think it's all great great that as law professors, we have these articles published in the Korean Law Journal and so forth. But I'm concerned about the level of education at the local level in those countries. We need to have more of a sort of epistemic communities, people on the ground, grassroots communities, who are educated about, plastics and all the pollution and stuff running down from agriculture. I don't think, as a person from the Caribbean who does some research in this, I don't think there's sufficient education on part of the populace, the people in those countries, about what they themselves can do better to mitigate some of these problems. So I'm wondering if you had any insights about education campaigns in Haiti in particular, from any of these international organizations that you work with, to sort of educate local people.
Yes, it's a great question. When I went to the Twitter Basin, I went several times to sort of gather research, but at some point, I sort of went to sort of present my findings and say, or to validate findings, right? So to say, this is what, these are my hypotheses, do you all agree? It was mostly representatives from communes or departments, or local offices of national ministries. And I delivered my presentation in French, and about halfway through, I just felt like there was a disconnect or something was up. And I sort of said, I sort of like asked a question, and someone leaned over and said, like, I think most people here speak Creole. Could you deliver your presentation in Creole? And well, that I can't. So then we sort of adjusted, right? But there is that disconnect where you think that your message is coming through, but you're making assumptions that it's inaccurate. I think in my case, this study was done for the Inter-American Development Bank, right? So in some ways, that's the audience. But they do work, and there is acknowledgement as a general principle of water management that stakeholder participation is crucial and really important. That's often sort of just a line people say, and we're going to emphasize stakeholder participation. But to really do it well can be challenging and requires that sort of level of engagement with communities. Our water management plan would involve those communes and departments in being active in some water quality and community outreach activities for the water basin. So we're trying to do that, but it's a huge challenge.
Yeah, because there's no political will, of course, but I think that more needs to be done across the region. We have the same problems in the Caribbean islands. That's why we have so many hurricanes and so forth in recent past, where I see people taking their water bottles and dumping them in the ocean. I mean, these, to me, and they don't know what it's doing to the entire ecosystem. So I really believe that that's where the major effort needs to be now, is on the local populations.
There's little E education, there's big E education. In South Africa as well, you do have the problem in local communities. Although in the urban areas, there's very little that people, it's not clear to me what education would actually do in urban areas to help people get more water, because they conserve every last drop they can, and there's the problem with leaks in infrastructure, which they have very little capacity to be able to fix that infrastructure. But you also have in South Africa the same big E education problem that you talked about in Haiti, which is that water services delivery has been devolved to the local level. There is no capacity. There's a critical shortage of water engineers. The public education system is, when I was there, it was ranked 143rd out of 144th education systems in the world that was challenged. So you're not generating new generations of leaders who are going to be able to manage the water infrastructure. So you've got a big E problem as well as you devolve water management to local levels.
Unfortunately, we have run out of time. But I would like to thank David and Ryan for their really enlightening presentation.